A good day to you out there. I'm Dali Pascal, your host on Justice, Lawyers Hangout, where lawyers dissect legal issues. And today we are more or less having a discussion on episode 2 of the topic data protection. We had the episode 1 some time ago. You do yourself some good to check it out on our pages. And today I'm having a one-on-one with Mr. Shidi Odo to take off or continue from where we left off as of the last time. Mr. Shidi, you're welcome.
Thank you for having me.
How are you doing today, sir?
I'm great. I'm fine.
All right, sir.
How are you too?
Oh, bless God. It's a pleasure to have you in the studio once again, sir.
The pleasure is likewise.
Yeah, so let's dive straight into it. We talked the last time, it was a 4-man panel where we were having discussions as it relates to data protection and the place of data protection under the Nigerian law. For the benefit of our audience out there, can you do a little bit of a recap on what we did the last time so that we'll know where we take it off from as it relates to current cases and in Nigeria on data protection?
Okay, my viewers, you're welcome. First of all, I need to start by saying that data protection is an offshoot of Section 37 of the Constitution of the Federal Republic of Nigeria,
Very well.
which guarantees each citizen or individual fundamental rights to maintain privacy of homes, communications, and correspondence. Therefore, Data Protection Act was enacted in 2003 to further elaborate on the constitutional power and mandate under Section 37 of the Constitution of the Federal Republic of Nigeria. And in the preamble to the Data Protection Act, the law stipulates that the essence, the reason for this act is to enforce people's right, to protection of people's right as guaranteed under the Constitution of the Federal Republic of Nigeria, especially Section 37 of the Constitution. That is the main reason why Data Protection Act was enacted in the first place. Then, what is data protection? Data protection is the aim of the law is to protect people's personal data, people's statistics. Example, people's name, PIN, business details like personal number, BVN numbers, people's name, email, phone numbers, residential address, race, sex, and other information that are private and sensitive to individuals, because the exposure of such data to the public may harm the person either mentally, financially, or commercially. So that's why the law, in its wisdom, has decided to enact a law to protect people's privacy from being circulated to the public without their consent or authorization by the law or the commission.
Very well. Very well. That is well said. Considering the ongoing level of awareness, I recall the last time we talked about the place of the National Orientation Agency in giving awareness as to issues of data breach and how people can go about their ventilating their grievances or getting justice when there are issues of breach in data. But you as a person, a practicing lawyer, a seasoned one at that, do we have instances of cases in Nigeria where currently that we can make reference to, and that they have been a part of, pending in court, judgments given, that listeners out there can benefit?
Data protection has become prominent, is in the front burner because of digitalization and globalization.
Right.
Because of digitalization and global, the world, the boundaries of the world, the boundaries have collapsed, and all the worlds are now a global village, where any communication, any information, statistics, or data can be everywhere and all over the world. So Nigeria is an evolving, scenario for data protection. However, no matter the recent enactment of Data Protection Act, you know that Nigerian data protection regulation has been in existence before the promotion of the act.
True.
So there are plenty cases in Nigerian courts now where these cases are tested. The position of the law, as encapsulated by Wendell Holmes Jr., is that the law is not law until the philosophies are tested and said by the court. Whatever the court say, is the law. However, in Nigerian cases, there are plenty cases in Nigeria. For example, ACOSA versus CATS Internet Services Nigeria Limited. The said plaintiff normally buys food from a Jumia app, which is hosted by the CATS Internet Services Limited. He supplied his data before purchases of food. After buying food from them, then the owners of Eat and Take Away, which is Dominion Pizza, started sending him information, marketing emails, marketing chats, marketing correspondence. He now wrote to the defendants that I don't want this communication again. You people are misusing my data. I supply data for purposes of buying food only. So people should not use my private information for the purpose of solicitation and marketing. He communicated to the ECAT Internet Services and the owners of Dominion Pizza And they refused to seize the communication. He went to court, and the court said yes, that under Section 24 of the Data Protection Act, that data provided is only for limited use only. And he supplied the information and the data for the purpose of purchasing food from Jumia Foods. Then that it is wrongful for Dominion Pizza and their company to start sending him email marketing correspondence when he has specifically objected to such emails. You know, under Section 26, there must be a consent before they can use your data. He now warned them to desist from...
by way of writing.
He wrote to
all
the defendants, but they refused. He went to court, and court said, no, you don't have the right, to continue to use his data. Section 24. It must be for limited use. It must be for proper use. That is an abuse. And awarded, I think, 3 million naira in his favor. Against Dominion Pizza, the eat and take away company. He awarded 3 million. But the court excused the first defendant, the internet provider, the data processor, on the data controller, because they said we have communicated to them, telling them to cease from sending email. But they continued. They excused them, but they fined the other people. They gave judgment against them for 3 million. That is not all. In the case of Fola Shade Molahin and UBA, she gave them her account number to pay her money in dollars to her. Instead of paying the dollars or converting it to naira and paying it to her service account, UBA went and opened domiciliary account for her without her consent, using her private data without her consent. They just saw her data in their system and started using it. The court said no, that data was supplied only for his service account, and you are in the custody of the data controller. You don't have right to use the data without express consent of a Fola Shade. And court awarded judgment against UBA in her favor. So the issue of data protection has now come into front burner. A lot of cases are pending in court over data breaches. In PDNPA initiative and the Nizmaya Hospital Limited, the plaintiff in the court said, you people have camera and CCTV and you did not warn me about the CCTV. And then he filed some private data with Nizmaya Hospital. However, the court said, no, you went there on your own volition for your data to be taken. And the data were taken for the purpose of medical examination. And for that purpose, you have consented for your data to be used for your own personal consumption, for your own contract, which you have gone there. And the court said, no, you don't have any, you have cause of action, but you don't have any right to damages because you consented to. The law allows such use when it is properly used and the fair use, because he did not bring any proof that the data was being misused. Only he said they collected without it. He said, no, they are using it with your consent. However, another angle to the case is that the court, the Federal High Court, held that NGO has right to bring data protection cases in court, because under the Fundamental Right Enforcement Procedure Rule, the rule empowers NGO, non-governmental, like any other person, to bring application to enforce fundamental rights. Fundamental right to privacy is also enshrined in Section 37 of the Constitution. So every NGO has the right to bring application to enforce data protection in Nigeria, based on the holding of the court in that particular case.
Well, given the peculiar nature of our legal jurisprudence,
yes,
our Nigerian legal system, and the chase for justice and the procedures, how rigorous it can be, I know.
Yes.
It's one thing to get judgment. It's another thing to be able to enforce. How does the enforceability go? What are people who are seeking justice in terms of breach of data expected to meet at the point of enforcement, even when these judgments are given in their favor?
The court is court. Despite data protection, court is court. You have to enforce your right. The problem is that many people don't want to enforce their rights. Without people challenging their rights, people will not sit up. All these changes we are seeing now are the efforts put in by some prominent fighters who have gone, our forebearers, our forerunners, who have gone to challenge the law and where we are. So you can enforce your law. There are plenty of ways to enforce the law. You can enforce the law by guardianship proceeding, by attachment, by any other means. which the law recognizes under Judgment Enforcement Rule or Sheriff and Civil Processes Act. So you have to hire to enforce your law. For instance, if you get a judgment against a bank, UBA or any other person, you either attach the account to CBN or seize their property or use the means, advised by law to enforce your right.
Thank you very much. That is well taken. We'll go on a short break.
Hello, this is Leadership Corp, Justice and Economic Advancement. Here at LJE, we offer education and empowerment, entrepreneurship and development skill, legal advocacy, promoting justice and equity, and job creation initiative. You can reach us on 0705 236 8821 or 0705 245 3714, or you can visit our website at www.ljenigeria.org.
You're welcome back from that very short break. Before the break, I think we were talking of some cases in Nigeria currently where Mr. Shidi mentioned Eat and Take. That's Domino's Pizza, a case against Domino's Pizza for breach of data, and a good sum was awarded in
3 million naira damages for persistent sending of correspondence and email marketing.
Does that fall within the ambience of what we call cyberbullying, not cyber stalking?
Well, cyberbullying, if you are talking about cyberbullying, you are talking about Cyber Crime Act under Cyber Crime Act of 2015. It's not cyberbullying per se. Yeah, it's annoying, it's irritating, it's
like that of this this Temu.
Temu, yeah, it's annoying. It's annoying. But the case was not based on cyberbullying or cyber harassment. Their case was based on you are using my private data for purposes I did not consent to. You do not use it for limited use. You have to use it for the purposes of which I gave it to you. You are not abusing my private data by sending it to companies to be sending me annoying, irritating, and messages that are causing me mental health and anxiety.
Mr. Shidi, you are an organization.
Yes.
Hypothetically.
Yeah.
You are an organization.
Yes.
You are with my data.
Yes.
For a particular purpose.
Yes.
How long are you supposed to be in custody of that data?
So far, you are with my data, and maybe I come to your law firm for the purpose of doing a matter for me, and you collect my data. Once the case finishes, you're supposed to erase my data. You're not supposed to keep my data again.
Is it a right?
It's a right. Because the limited purpose of the data must be for the case only. You cannot use my data now for maybe purposes of other things, for campaign, adverts, or sending it to people to be sending me. No, it must be for a limited use. Under Section 34 of Data Protection Act, the use must be for a limited purpose. You cannot use it for any other purpose other than the purpose for which it was meant for.
I'm saying now, all right.
Yeah.
You have the data.
Yes.
You have used it for that purpose.
Yes.
How long should it be with you?
For as long as the purpose, if the purpose has expired, you have right to. I can demand for the data to be deleted. That is what happened in the case of Olatokunbo Olakan and the Polaris Bank. She wrote to Polaris Bank, say, I don't want you people to have my account statement, account detail. Close my account for me. Erase my data. The purpose for which I want this account has expired. I don't want to back with your bank again. Erase my data. Erase everything about me. But the bank refused and continued to send mail and messages to her. Say, no. I said, remove my data, delete my data, and they refused. She went to court, and court awarded damages against the Polaris Bank for failing to erase and delete the data because the purposes for which the data was meant for has expired.
That brings me to our next question.
Yes.
How do I ascertain that my data has been erased?
Well,
you are with my data.
Yes.
Yes, I have that right of erasure,
yes.
right? You should erase it after using it for the purposes for which I gave you that data, all right?
Yes.
Now, how do I ascertain that you are no longer in custody of my data?
Well, you can use a practical way. You can write to them to delete you from their system.
Okay.
Do you understand? And they watch. If any other thing happens, you will find out that your data is not still with them. For instance, if they send message to you or do any other thing, it is a proof that the data has been, or you see your data anywhere. Because most often it may be difficult for you to go into their system to know where your data has been released or not, erased or not. But once you have given them instruction, any other thing contrary to instruction on your data is actionable, and the court will award judgment against you.
Now, you are on the field.
Yes.
You are on the field. You are very familiar with this terrain, issues of data protection, the breaches, the rights, and all of that, all right?
Yeah.
How aware we're talking of Nigeria now,
Yes.
so let's limit it to our client.
Yeah.
How aware have our people become on issues of breach or on issues of data protection? How much knowledge of
People don't
what
know,
data
they don't
breach
know,
or
they don't
data
know, people
protection?
don't know anything about data protection. Most people are,
That is you speaking frankly.
yes, people don't know much about data protection. People are hungry. So if you are telling them that you use my data for, they are not interested.
Very
Only
well.
time the people will be interested is maybe you use their data and in the process commit crime, or in the process commit a cyber online crime. That is when people will be interested. Like for instance, if you take my ATM card and use my private data and hack into people's account, that is the only time the masses are interested. But if you use their private data for any other thing that is not hurting them directly or that is not causing them economic harm, they are not interested because people are hungry. They don't even have money to consult a lawyer. They don't even have the process of meeting data
That's the
protection
point.
commission.
That's
So
the
most often they will just allow it to slide. For instance, if you go to Motor Park and then they will feel manifest, people will go and copy the number there and start sending you message. You know, immediately you leave.
And they are given out at a good fee.
They are good at a good fee. They are sending you messages and all those things. So if because most say, why will I'm in Lagos and they're using do I have money to? So people are not very much aware of their right to sue or to challenge people using their data for improper use. People are not much aware. It's only people that are enlightened that are going to say, you are misusing my data, so I have to go to court to sue you, as exemplified in all the cases we have mentioned before.
Okay, now in like issues of, we're talking generalistically.
Yeah.
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 Like issues of libel, defamation, and all of that. You need to establish the fact that you suffered some either loss or some damage to your name and all of that. In data protection, must I establish or speak to the fact that I suffered or there are some economic loss on my part or whatever?
You don't need to state that you suffered anything because
That
once
must-
you established,
It mustn't be proved.
you don't need to prove the actual damages you suffered. Once you have established your data has been breached, it's actionable per se, and you must be given damages.
Now the
For
hard
breach
question.
of your listing. Yeah.
Now the hard question. Sorry, I'm
Yeah.
cutting you because
No,
I'm
it's
trying
okay.
to manage time.
It's okay.
Now the hard question.
Yes.
You are a lawyer.
Yeah.
The NBA elections and all of that are coming in a moment.
Yeah.
All right. This continuous bombardment of lawyers with messages from people they don't know for the purpose of election, or even some of the messages we get unsolicited from even the NBA, does it amount to a breach of data?
One, it is invasion of your privacy under Section 37 of the Constitution.
Very well.
You have fundamental right to your privacy. So any letter, email, or message you did not subscribe to, and they continue to bomb you with that, is a breach of your data privacy.
So it is
It
safe,
is a breach of your private life.
it is safe to say that even within the legal community,
Of
there
course,
are issues
people
of data.
there can be issue of data breach. But however, remember that there's what they call volunteer with non-injuria. You are a member of NBA. You have the election is coming on. Everybody is making campaign. Everybody doing campaign. So sometimes the law may excuse such. But however, if you write directly to the people that you don't want such messages to come to you, I think they have to desist. If they desist, it's actionable.
So I must warn you first before I
It
enforce
is
my
proper
rights.
to warn the people that I don't want this thing you are doing.
No, there's a difference between being proper and must.
No, it is. Yeah, it is.
Must I warn first?
Yes, before you go to court, you must warn them.
Okay.
It is proper to warn them that they are breaching your data.
I'm trying to say, is it a condition precedent
It
to
is not
filing
a
an
condition
action?
precedent, but you know that most often it is better to bring it to the attention of a person that is breaching your right. Say, you are breaching my right. I don't want you to continue breaching my
How
right.
do I know who gave them even the information? Because who I'm
No,
going against may be the wrong person.
No, once you get the people that send you the email by either phone number, email address, or WhatsApp, you say, I don't want this message again. It's breaching, it's invading into my privacy. It's causing me mental harm. It's disturbing me, it's causing me anxiety, it's disturbing my sleep. I know a case somebody did against the MTN. Say, all these unsolicited messages you are sending to is distracting my sleep. And he was awarded 5 million naira damages in his favor. So if I say, I don't want this, you are breaching my privacy. How did you get this thing? Stop sending me unsolicited messages. It's disturbing me. It's actionable per se. Yes, it's actionable. To the person that is sending you this message, you may not know where they're getting your information from. But you can
I can now put it to you.
put it to
No,
data protection
I can now put it to you
organizations.
that your immediate constituency, being the
Yes.
Nigerian Bar Association,
Yes.
also have questions to answer on.
They don't have questions. I said that most lawyers are in different platforms.
Yes.
Lawyers platform.
Yes.
Those messages are being sent to lawyers platform. Now, this is a season of campaign. People are sending and receiving. Lawyers are also campaigning for people.
Very well.
People are also campaigning, in favor of other people. So when they continue to send you message, I said, if that is annoying to you, because that is a season of election, you are a member of the organization. Campaign. Everybody has right to participate in voting and being voted for.
Very well.
If you don't like it, you write to the people. Say, I don't want this thing. I'm a member of this organization. I voluntarily joined this organization. But this unsolicited messages are disturbing me. If you write to them and they refuse or persist in sending you the message, is actionable. That's what I'm saying.
Natasha, it's been a very wonderful time with you, as always, in the studio.
Thank
We hope you'll be available to
Anytime.
come around some other
Anytime.
time so that we can have this kind of chit chat.
We as lawyers, we will have the obligation to educate the masses.
Thank you very much.
You're welcome.
I'm glad you understand that and you are keeping to the dictates
You're welcome.
and the mandate of the lawyer. It's not an easy task. So on data protection, we've heard from one of our very good experts here, Mr. Shidi Odo, as it relates to issues of breach, cases that are ongoing, cases that have been determined. And you can as well be one of the clients who they are looking for out there in the event that you feel there is a breach of your data protection or your rights per se. There's a lot of data breach, data issues going on currently, and I'm very sure in a very short while, the awareness would be more than it is now.
Yes.
So we need to stand to it. The National Orientation Agency, I'm an advocate for intergovernmental agency synergy. The National Orientation Agency has a lot to do in that regard. The Nigerian Bar Association has a lot to do on that regard. And I know for a fact that the Nigerian Bar Association do conferences, seminars, and talk shows, even online, visually and physically, where this education, this knowledge on prevailing new grounds in law are always put out there. So we've heard from the experts, we've heard from Mr. Shidiodo, and so you do yourself some good to follow up on the conversations, link up with us on LJE Nigeria on all social media platforms. We'll be there to receive you, take your questions, and then to keep educating. That being said, may the odds remain in our favor. Your host, Dali Pascal, on Justice. It's a wrap.